Hi guys, it's Kathy. Oh my goodness. Do I have some for you today? Get excited because these are so good. Yes, yes. I got a great Sov Cit. Of course, we're going to start there. So if you come on late, just play it at double speed or whatever to catch up, but don't miss it. Don't skip it. I got a couple pro says, not just one. I got a couple pro says. I got people who get arrested. I got people who reject the greatest offers I've ever heard. I got people with issues. And that doesn't, none of what I said includes California. California, I have no idea if it's a full moon. I know it's not because it's on the 25th. I looked because that's how crazy it was today. But California is just going to be the whole end of the clip because there's just too much going on. But let's start. Let's just dive right into Sov Cit. Let's go Sov Citizen because, they make our day. They keep us on our toes.
So the charges that you're facing are misdemeanor, one misdemeanor traffic offense and two traffic infractions. Those are failure to display or provide proof of insurance, driving under restraint, non-alcohol related restraint, and driving an unregistered vehicle. That's counts 1, 2, and 3. To counts 1, 2, and 3, how do you plead? Guilty or not guilty? Or no contest? I accept no contest pleas all the time. But
Objection, Your Honor. Are you practicing law from the bench?
how do you plead, Mr. Lawton? Guilty or not guilty?
I'm innocent.
Okay, I'll enter a not guilty plea. And would you like to set the matter for a jury trial or a trial to the court?
Your Honor, can I ask you a couple questions?
No, I've already said that. You already asked me that. And I said, no, Mr. Lawton, this isn't school. I'm not engaging in, I'm not charging you tuition. I'm not playing any games with you. So no, but you can tell me what kind of trial you would like me to set, and I will expedite and set a trial. And you do have a choice to make. You could choose either a jury trial. That would be the jury commissioner would summons jurors in for any jury trial date, and then you and Mr. Turner can select a jury to hear and try the case, make findings of fact, and determine whether or not the DA can prove the charges, or you can waive a jury, which I'm not suggesting you do, but you could if you wanted to try your case to the court, and that would be a trial to the court to a judge without a jury.
Your Honor, are you a public servant?
Mr. Lawton, I mean, we kind of talked about giving and getting respect, and I'm doing my best, but I'm not going to sit here and answer questions and engage in your nonsense.
I don't know how I can take you seriously unless you prove that you're a public servant.
I'm trying to take you seriously.
Have you taken an oath of office to the Constitution of the United States of America?
My oath is on file with the,
I'm
well aware.
Can you provide it for me to examine?
I cannot, sir, but it is filed up.
And I fail to see that you have jurisdiction to be addressing me.
And I've addressed the jurisdiction issues. I've tried to make the best record I can at your previous court hearings.
For the record,
stop interrupting, because I'm not interrupting you except when you continually badger me. So I would refer you back to December 26. You ordered a transcript. I made the best record I could, and I cited law about jurisdiction. You want to go back and rehash and replay. I'm not going to do it. I am going to move the case forward. And my job today, what I have to do today, is determine after a pretrial conference, which you and Mr. Turner conferred, which is good,
Your Honor,
whether you have a disposition. But you don't. That's what he told me, and that's what you're telling me.
Your Honor, you consistently interrupted me. I have questions that I would like to ask.
Okay, so do you want to set a jury trial or a trial to the court?
I have questions I would like to ask. For the record, I do not waive the presentation of the penal bonds. I would like to see the penal bonds and specifically the performance bond.
Mr. Turner, I'm inclined to set a jury trial. Mr. Lawton could always choose to switch it to a trial to the court, and it's easier if he waives a jury, and I'm not suggesting that he should waive a jury. It would be harder for him to then exercise his right to have a jury. So Do you have any objection to the court setting a jury trial?
The people have no objection to that, Your Honor.
All right, not guilty, please enter on counts 1, 2, and 3.
Objection.
Jury trial will be scheduled. I'm going to set it, I have 180 days to get the case to trial. Mr. Turner, I'm going to set it way quicker, but.
Are you going to rule on the objection, Your Honor?
Objection is overruled. I'm going to set it.
On what grounds do you overrule that objection?
I have no idea what you're objecting to.
I'm objecting to you putting a plea in and practicing law from the bench. I have not put in a plea. I'm innocent.
Yes, and I said pursuant to the rules of procedure. You're not the first gentleman or lady who.
Do you have a contract that obliges me to those rules of procedure? Do you have a claim against me?
I have no contract.
Do you have a claim against me? You have no contract with me. Do you have a contract with me?
Mr. Turner, I'll
Does anyone in this court have a claim against me?
I mean, I'll stay here.
Does anyone in this court have a claim against me?
I was trying to refer to the rule, but Mr. Lawton thinks if he just speaks over everybody.
Does anyone in this room have a claim against me?
I was trying to refer to.
Let the record show that no one in this room has a claim against me.
If the defendant doesn't want to enter a plea, the court should enter a plea, and it should be a not guilty plea.
I request that the honorable judge direct the prosecutor to answer whether there are any more charges.
The charges that are being set for trial are the 3 counts.
I request that the honorable judge direct the prosecutor to provide the assessment of the charges as well as a certified audit trail of all transactions, including vouchers, as well as all disbursement documents and receipts. For the record.
You good? Can I continue? I'm on call this week.
I've made a request. I would like to have the penal bonds presented. I would like to see the performance bond.
I've heard your request and it's respectfully denied. So I respect that you have everything figured out, and this is.
Do you have a claim against me, Judge?
So.
For the record, do you have a claim against me? Do you have a claim against me? For the record, do you have a claim against me?
Mr. Turner, I'm looking at May.
Mr. Turner, do you have a claim against me?
Mr. Turner, I'm looking at
Mr. Turner, do you have a claim against me?
Mr. Lawton, stop. You can't do that.
If no one has a valid claim against me, then I instruct the judge to dismiss the charges and eliminate them
And the
with
judge
prejudice.
is denying your motion to dismiss, Mr. Lawton.
Based on what authority?
I would refer you back to all of the authority that I tried to respect.
Has the judge made a judicial determination that I shall be denied my Sixth Amendment guarantees of
No,
due process?
I will appoint an attorney if you would like to fill out an application for
Do you-
public defense.
May-
Stop. You're just speaking over. You just raised the Sixth Amendment. Do you know what the Sixth Amendment is? If you do, let me answer it. And stop. This is your behavior, Mr. Lawton. I mean, please come back to reality, but stop. And you have to understand.
I do not understand.
Okay, that's fine. You can be out in Planet Lawton or not understanding, and I will try my best. But you asked about the Sixth Amendment. Stop.
Tell me when it.
Stop.
Will you tell me when it's my turn?
Yes. Sixth Amendment is your right to an attorney, and I can appoint an attorney from the public defender's office. I have applications.
Please
If
don't.
you'd like one, I will definitely give you one.
Don't give him one.
But just continuing, because whatever you're referring to, I have to be able to answer your question. So that's the question. If you would like an attorney, I do think you can run things by an attorney, and I can even appoint a lawyer for you. It's not a lawyer of your choice, but it's a lawyer from the public defender's office if you qualify. If you'd like an application, just stop there, tell me, and let me give that to you, or let me have the clerk of court put it up there so you can grab it yourself. So you have that option. If you don't want an attorney, that's all right. You have the right to represent yourself, but you have to understand, as you represent yourself, there's still rules that apply to you. So you're representing yourself. Great. That's good. But I can still enforce rules and set rules, and that's what I'm trying to do. And I'm not going to escalate with you other than like to keep you from like just going off, and I'd like to avoid holding you in contempt. I can respect you
Taser.
as a participant in this court, without necessarily agreeing with whatever ideas you think apply to you that don't apply to me or don't apply to anybody else, that's fine. So if I said something disrespectful, which I feel like I just did, I apologize. The planet part. I'm trying to tell you that I'm trying to just get through this thing, which is what I told you on December 26th, the day after Christmas, and I told you in February. What I have to do today is just navigate a pretrial conference, and you guys had it. Good work. You haven't settled the case. Fine. The next step is for me to check in with you. You don't want to enter a plea. Okay. I heard you. You said that. I believe the rule of procedure does, I can't enter a guilty plea for you, and I can't enter a no contest plea. So my only other choice is a not guilty plea. So that's just like anybody. I entered a not guilty plea, and now I need to set a trial. You haven't picked, so I'm setting a jury trial. You can always shift gears, but I'm starting with the jury trial. If you want an attorney of your own, you do have that right, and I can appoint a lawyer. Now, the next issue is if you want discovery or reports or anything at all, I am ordering Mr. Turner's office, the DA, to give that to you upon request. You do have to make a request, but then they have to provide it for you. District attorney has to file endorsements of witnesses. They have filed them on December 18. District attorney has another deadline to meet, which is 35 days prior to trial. And that's what I was trying to advise the district attorney. I'm setting a trial date quickly. It's well within speedy trial, but please don't lose track of the 35-day prior to trial deadline. There's a number of other trials that are probably older than your case, so yours may not go. But I am going to get it set up for a trial track. So do you accept, does the district attorney accept May 16 at 8 a.m.?
Yes, Your Honor.
Okay, Mr. Lawton, that's just over 60 days. It has to be brought to trial within 180. So there's a lot of time, but I'm going to set it first, May 16th at 8 a.m.
Objection.
Okay, your objection is noted. Do you have any specific objection to that day? It's a Thursday. Or is this like a general objection to the trial?
It's an objection to moving forward. I have some questions that I would like to have asked before I answer those types of questions. I understand you're trying to move the trial forward or move the case forward or whatever you will. It feels to me like you're rushing me to judgment, and I don't appreciate that. I have some questions that I would like to answer. They're very sincere questions about the nature and cause of the claim according to my Sixth Amendment right. I still, after my third special visitation to this court, have not been informed of the nature and cause of this action, and jurisdiction can be challenged at any time. I have some very simple, straightforward, and important questions that I would like to have answered before any of these things can move forward, before I will consent to any of these things. And first off, I'm here under duress, coercion, and threat of violence from the very beginning. From the very beginning, I've been misaddressed. I've entered a new document into the court file. Have you seen it? Have you read it? Would you like me to read it into the record? I would love to read it into the record.
Objection, hearsay.
The clerk of court took filings from you on March 6 and March 11, so those are preserved.
I would like to read it into the record so we can discuss the points.
I'm not going to have a discussion with you. You don't have the right to read, but I will tell you, if it's the document you filed on March 6 or March 11, the clerk of court took it and has preserved it for the record. And so certainly if you want to follow up with anything else, you can, but that's not what I'm doing today. And
It's
I'm
in
not
the shredder.
discussing anything. Okay, so I've preserved your objection to the trial generally, but I want to make sure May 16 is a Thursday at 8 a.m. So if there's anything specific about that, for example, you have a medical appointment. That would be what I'm asking if there's a more specific objection to Thursday, May 16th.
I object to all days
Hearing
ending
none,
with Y.
That's going to be the first setting of the trial. But I have heard your objection about me setting a trial. All right.
The reason I keep speaking up is because I don't wish for my silence to be interpreted as acquiescence.
You haven't acquiesced to anything.
Wonderful. I want, for the record, I reject any presumption of contract or any presumed degradation of status by crossing the bar or participating in this setting. As I mentioned, I'm here as the sole survivorship interest in the Nicholas Reed Lawton estate. And I resent and object to the prosecutor addressing me and filing charges against my estate. And I would like to see his bond immediately. I don't know how he's even addressing the court without putting in a bond. And I think it's a perfectly reasonable thing for him to come to court with the bond. Why doesn't he have it right now? Why is it not in my hand? I would like it in my hand right now.
Your Honor, I'm not aware that that's even a
And
thing.
if there's not a bond in this case, then I instruct you to dismiss.
Yeah, I've heard you make that request a couple of times, and I've respectfully told you that I'm not going to grant your request for dismissal.
May I see the penal bonds? May I see the bid bond?
Kinky.
At some point, I need to just
May I see the bid
call
bond?
it what it is, which is, you know,
Is there a bid bond in this case?
it's like people can ask for something nonsensical.
Will you
and that's
answer my
essentially
question?
what's
If
going on.
if there's not, it should be easy to
if you
answer.
have
If there
any-
is, it should be easy to answer. Is there a bid bond in this case?
Does the district attorney have any other issues with regard to trial management, trial scheduling, motion issues, or discovery?
Your Honor, I don't believe we do. And in fact, I believe we made discovery available to Mr. Lawton previously. I don't know if he did have an opportunity to pick it up or or if it was, or if he received it via mail, but I think we did make an effort to deliver that to him.
Okay, yes, that's what I keep reiterating, that any accused is entitled to receive discovery, just with the simplest of requests. Any sort of pretrial motions that need to be set for a hearing?
Your Honor, I don't believe so. Not at the moment.
Mr. Lawton, any motions that you'd like to have set for a hearing or other?
Objection.
To me asking if you have any motions to be set?
My name is not Mr. Lawton. I'm here by special visitation as a living man. My name is Nicholas Reed. And I object to being addressed as anything else.
Your objection is noted for the record. Is there any other motions you want me to set for hearing or anything else you want to do along those lines?
I have some questions. I still wish to challenge the prosecutor standing to invoke the jurisdiction of the court, the nature and cause of the claim.
All right. Your
May I-
objection of jurisdiction is noted, and
Your Honor, I'm confused. Maybe you can help to clarify.
I can't.
Is-
That's
is-
not my job.
I am not asking.
So I advise you again, as I have in the past, you have an active warrant from Fremont County. 2021 T299 is an active warrant from Fremont County. And so I just advise you again that you should consider remanding to either the court that issued the warrant or the county jail. It looks like you did write a letter to Judge Roback, and she responded confirming the defendant is on warrant status. The court takes no action until the defendant is back within the jurisdiction of the court. So I just putting you on notice of that and trying to let you know again. Otherwise, the case is set for a jury trial May 16th
Objection.
at 8 a.m. And that concludes the
Objection.
proceedings today.
Your Honor, I have more questions.
And as I said, Mr. Lawton, I'm not here to answer your questions. So court goes off record at
Your Honor,
You are-
my understanding, you have a constitutional duty to provide me with the nature and cause of the claim according to your Sixth Amendment, your Sixth Amendment obligation. May I see your oath of office?
off record at 4:11 and
That's it. He went off air. He said, I'm done with this. I did my best. Way too nice. Way too nice. Where is contempt? Contempt is a law, right? Like contempt of court, that is a thing. Why don't any judges use that? Maybe it's not. Maybe I made it all up in my head and there is no such thing as contempt of court and judges just have to let people do whatever they want to do. That's what I'm thinking. All right, let's jump from a pro se Sov Cit to just a pro se. Hi, Cha.
Your Honor, if we could,
I think I'd like,
go
I'm
ahead.
sorry. I think I'd like to call Mr. Chisholm because I think that might, we've
Okay.
got some things that are up in the air on that one. Is Carl Chisholm?
Yes, ma'am, I'm right here.
All right, sir, can you come on up so I can hear you?
Yes, ma'am.
Thank you. This is 2022 T203 and 2022 T239. Good
And
afternoon, sir.
also ticket 3156, Your Honor.
Okay, we haven't received that yet, so I'm not doing anything with that. We don't have a file
Okay.
on that ticket.
Okay, nobody seems to have a file on that ticket.
Yeah, I can't help you with that today, sir. What I do note is looking through your file, you had a motion to dismiss that was pending, but I understand that there was a filing by the district attorney's office that you had contacted them and requested a continuance so that you would
Yes,
have
ma'am.
more time.
Yes, ma'am.
So-
Today, my sole purpose of being here is to waiver my speedy trial rights and reschedule the motions hearing date, as well as the pretrial and the trial. I've already spoken extensively with Mrs. Scott, and the district attorney's office has also been informed of the change. And if it's okay with the court, okay, it's been advanced to May the 7th for the pretrial, June the 7th for the
Hold on,
pretrial.
sir. Hold on, there's a couple things I have to ask you because waiving your speedy right, I need to verify that you understand that you are entitled to have a jury trial within 6 months of your plea.
Yes, ma'am. And if I
And that, sir, by waiving
recollect
that,
correctly, okay,
sir,
I would.
sir,
Oh,
please,
go ahead.
I need to ask you some questions. I can't proceed any further without verifying that you understand that if you waive your speedy right today, then your speedy gets reset for 6 months from today's date, which would mean your speedy would then be September 12th, 2024.
Okay.
Okay?
I
Do you
thought it
understand
just,
that?
I thought it just abolishes the actual right to speedy trial.
No,
Okay,
sir, you still,
because,
it resets it.
okay, okay,
Okay, so if you waive your 6 month speedy right, then from the date that you waive it, it extends it out another 6 months.
okay. Is it my
Okay.
misconception or the arraignment take place in September the 28th, I believe, of
It's not-
2022?
It's not from the arraignment, sir. It's from the time you enter your not guilty plea is when your speedy starts. So right now, your speedy is set to expire on May 17th, 2024. You're currently scheduled for jury trial March 25th. So
Correct.
are you wishing to waive your speedy right to have your jury trial by May 17th?
Yes, ma'am.
Okay, so we're going to reset your speedy to September 12th, 2024. Would you like to schedule your jury trial today, or would you like for us just to set the motions hearing and then schedule the jury trial after that?
I'd like to go ahead and set the jury trial June the 25th, which has
Okay.
already been established by your clerk and the district attorney's office.
Mr. Salazar?
Your Honor, I actually do recall, I think before we were in this position of trying to get this in earlier rather than later, but really, I don't know how many we have set on that July date. But if that works for the court, we have no objection.
Ms. Scott, can you give me the dates again for June, July, and August? And then how many we have in each one of those? Okay, Mr. Salazar and Mr. Chisholm,
Yes,
there
ma'am.
are June 24th is the jury trial date in June, and it has 2 currently. July 22nd has 1, and August 26th has 0. Mr.
You
Salazar.
want to go with August?
If we can do July,
You don't want to go to August?
no.
Give you plenty of time for the other cases.
Your Honor, if we could set it on that July date.
Okay.
Let-
Mr. Chisholm, are you going to be in town July 22nd?
July 27th?
22nd?
I believe so, yes, ma'am.
Okay,
It's a Monday.
so,
Is it Monday? I don't think that would be any problem.
okay. So we're going to set the jury trial for July 22nd, and that is in both cases. It will begin at 8 a.m. We'll have pre-trial readiness conference on July 9th at 3 p.m. in person.
Okay.
And
Motion's hearing.
we are going to set a motions hearing. And if there are any other motions other than your motion to dismiss, you'll need to file that within no later than 30 days before the motion hearing deadline. And the motion hearing will be June the 7th at 2 p.m. in person. So that will be on the motion to dismiss and any other evidentiary motions that are filed before May the 7th. And Mr. Chisholm, would you like someone to write these dates down for you?
Yes, ma'am, please.
Okay. Okay, sir, do you have any questions?
No, ma'am, not at this time.
All right. Ms.
I will
Scott will
have a
write those.
lot of them a little later.
Okay. Ms. Scott will write those dates down for you and get them to you. All right. Thank you very much, sir. Have a good day.
Thank you.
Mr.
Your Honor,
Self.
if we could call Cesar Jimenez.
So that one hurt my feelings a little bit, only because he did such a good job. I thought he did such a good job, but we both know that doing a good job is not going to be good enough for him. It's not. And since he did such a good job, he probably is walking out of this courtroom right now thinking that he's good enough. But he's not a lawyer. He's just not a lawyer. He tried very hard. I think it's going to go bad for him, and I feel bad. I just feel so bad for him. Okay. All right, this one, we don't even get to see a judge. Nope, no judges in this one. Don't worry, no magistrates, nobody on the bench, no prosecutor, no public defender.
Hi there.
He said there was, through the viewer, it said there was a punch in one of my bags, and there wasn't. It said there was a revolver in it, so we both seen the same thing, and it disappeared.
Crazy. If you'd like to just take a seat, I'll let the judge know you're
Yeah,
here.
please. And I have extenuating circumstances on why I'm late and more proof. And oh, you're going for part?
Hmm?
Is that just somebody sitting there?
Oh, he has an advisement scheduled at 4:15.
It's not okay.
So we're just waiting for the interpreter we're waiting for the interpreter to sign on.
I had my dog was taken from my house. I thought they killed her about a week and 2 days. Just yesterday on social media, and I have 7 puppies, it's like 6 weeks old, that are with me in the car.
Oh, wow.
Yeah, that's why it took me so long. Somebody took her from my house off the East 10 remote. Everything out there is BLM or posted no trespassing. They took my dog from there and took her to Pueblo. And just yesterday, threatening to take and destroy her if I didn't come get her. I have court today. Like, I got 7 puppies with me. That's number one. 2 is I put in the motion to be seen for the conflict of interest, and she didn't give me an opportunity to depict or prove myself. Everybody in the courtroom was not for me. They didn't show or openly. They're not for me because nobody let me listen or heard what I had to say. I brought all my proof and truth of Becky Briggs was already in Patrick McCarville already proved that his Trinidad Public Defender's Office is a conflict of interest from my last case. That's why Becky Briggs was brought in, and that's in your computers. These things should be stated, and it still is with this young lady, Lana, and that's what I'm trying to state, because my case is still wide open, and everything dealing with is conflicting. It still has to do with the same branch is conflict of interest, and that's all I want to do. And I brought my my credentials, my portfolio, my resumes, my professionalism, my I am, and my sister actually has legal custody and power of attorney, executor, and to all my possessions in the city. So regardless, I wouldn't step down and go. It would be stepped over to her, and she still asked me to be heard. Nothing has changed.
Okay.
So I just and I have this, this one at all. And the driver and person with the animals is outside.
Okay.
Is that one?
Okay.
Are we going by the minutes from this earlier or?
Yes.
Okay, so. Sure. Wouldn't stand up.
Oh, I was told it. I'm
Wouldn't
not.
stand up.
I'm not standing out.
You're under arrest. You have a warrant for your arrest.
Yeah. For what? Fiscal days.
You have a warrant for your arrest.
Y'all. Somebody took my.
Testify. Can you get to the courthouse with me?
I'm not trying to have any issues, but I got 7. Now, who the fuck are you talking to like that, bro?
I'm talking to my deputy.
Like for real. They took Chupa, and
I'm not gonna play with you, man.
I'm not gonna play with you, bro. I haven't done nothing wrong. They took my dog, and I have 7
That's
puppies in the
okay.
car.
Get over it. That's all. I'm coming involved.
Am I not gonna be able to talk to the judge?
No,
Okay.
he wasn't here too.
Mike Velarde.
You good?
I was like, I had 7. Y'all. That's Yeah, see, I don't drive, and I have 7 puppies in the truck, and my dog's about to be killed because they took her to fucking put her.
All right, I'm gonna put him in front.
No, you're
I'm
fine.
not gonna just.
Fine. You're fine.
Alright.
You're fine. I'm trying to keep on. I think you should it would be nice if you let the judge know that I did ma'am.
I'm letting him know right now.
Those with those.
Or her know, sorry.
Step out here.
And those
Do
yeah.
you have anything on you in your pockets? or
No,
anything
I
like
have a
that?
toothbrush.
Any needles or
No,
knives or anything like that?
That's my toothbrush. I couldn't eat it.
You got a phone?
Yep, I have. Yeah.
What's that?
Oh.
No, there's something square. Can I grab it up?
Yep. The other one is nothing but
Wallet.
wallets.
You got here just keys. Yep. Keys and you got your medication?
No,
Yeah,
I don't
okay.
have I don't have my meds with me. That's the other thing. I was hoping to get cleared up and prove that
All right, well,
no, you're fine. It's not you. It's
I'm just saying, I don't want you to chew up another.
yeah, no, it's gonna be if to house me, you have to have my meds or something to affect together.
Yeah, we're,
I know, but
that's why, yeah.
this whole thing is they keep charging me for the same thing, and I even brought my prison release and my care of my meds from Advanced Den. They know it's my meds. They keep harassing me and charging me for possession.
That's the wallet there, what's this right?
My other wallet.
Your other wallet?
Yep. To prove to let the judge know. Yeah, let the judge know I have all my stuff. There's conflict of interest that she's allowing the same branch to
That's okay. I got 1 minute of custody. All right, Mr. John.
yeah, just go ahead.
Oh, I'm done.
Okay. He clearly said the driver and his puppies are waiting in the car. The puppies are not all alone if there is any puppies, if there even is a car. which I have strong doubts about. But he said that there was a driver in the car waiting for him. So if there is puppies, the puppies aren't all alone. And I'm sure if there really is someone will go out, I'm sure they are. I'm positive they will. But okay, that was this courtroom. The next courtroom, this clip is only a couple seconds long, and I'm going to pause it when I start it so you can see where to look. Somebody has a medical issue, but I promise you don't see the person and you don't see the medical issue. All you do is see what happens in the court when someone has this medical issue. Okay, so let me pause it. All right, so if you see, there's the guy in the prison jumpsuit, and beside him is the public defender. And then in the background beside her is the bailiff standing. All right. Well, the guy who is about to have the medical issue is sitting on the benches behind him. So that's where you should try to look if you can. You don't see anything, but that's where it is.
I'm asking that the court consider setting a lower bond in this case. That way, should Mr. Rivera be able to post bond or receive another personal recovery.
Hold on. Is he okay? Yeah.
It's my point.
Is he may be having a seizure.
He's having a seizure.
He's having a seizure.
Every single person in there stayed calm, cool, and collected. He's having a seizure. First, he cut the light. Well, first the bailiff got the inmate out of there right away, and then the judge cut the live feed right away. Professional. Everybody was professional and kept their cool. The people around him jumped out of the way when he had the seizure, but it was just so professionally done, and they got help for him pretty quick. The judge came back on the bench less than 5 minutes later. Okay, this next guy, let's go to Georgia. I think it's Georgia. Oh yeah, it's Georgia. And first off, look how pretty the white panels are. Not dark, not medium. These are white.
This is an offer rejection.
All right. Mr. Davis? You're Mr. Davis, correct?
Yes, sir.
Very good. This is 22 FE 0208, State of Georgia versus Brian Latron Davis. My understanding is that we previously put an offer rejection on the record, but just since you're here today, we're going to confirm that. Mr. Davis, everybody's ready on your case. That means that it's number one on our list. Everybody's ready to move forward to this case. Barring something happening in the next 10 minutes that none of us foresee is going to go to trial beginning tomorrow morning. You understand?
Yes, sir.
Okay, and previously the offer to resolve this case was what?
Your Honor, it was 25 years on probation to serve 15. Trafficking is a minimum of 25 up towards a life. Then count 2, possession of cocaine, 3 years. Count 3 and 4 are both misdemeanors. So, and we were willing to throw in, he had another case in our office, which was 24 FE 0018, possession of meth with intent to distribute. That was a maximum of 30 years. We were willing to do both of them with 25 served 15.
All right. You understand all that, Mr. Davis?
Yes.
All right, and that offer is rejected, sir. Very good. All right. Yeah, I apologize.
Yeah, I reject the offer.
Very good. Thank you. That is sufficient. All right, Mr. Davis, your case will go to trial.
Thank you. Do you have an outfit?
No, ma'am.
Can you call your family and try
And
to
Your
know
Honor,
where you
now
are?
it's two, he is a recidivist, 3-time convicted felon.
I'm gonna call when I get back.
Okay. Just make sure.
Notice
you're-
has been given.
Did she explain it?
Drop him out.
I'm sorry?
You explain recidivist to him,
No.
but he needs to know that
All
part.
right, Mr. Davis.
Mr. Davis.
They want to just put on the record that you know that with recidivist, you would not be eligible for parole. You'd have to do every day to what you're sentenced to. You're aware of
understand?
that, correct? Okay.
All right.
Yes, please, Mr. Bradley. That's what you can do.
And number 2.
Okay, so Mr. Bradley, again, you're here on 23 FE 0131. And we've previously come to court and the offer's been put on the record and rejected. As it stands right now, your case is position number 2 as far as priority goes for going to trial. This trial week, the parties have announced ready. So if our first case were to fall through, then yours would be the one up. The offer is, let's just put that on the record again, Mr. McClendon.
Your Honor, we came down on this offer. It was 20 served 5, he's rejected. Failure to register as a sex offender is 30 years. And then also possession of a firearm by a convicted felon, that's 10 years. So he's facing 40 years. He is a recidivist. We're trying to get his convictions from Connecticut up there. We have 2 certified copies already, the court has. He already has another conviction for a case we tried, I think, in the last year. But there's also 2 or 3 more from Connecticut convictions we're trying to get certified copies of. But notice has been given. He will be recidivist. But he has served the max.
You understand the provisions of how the recidivism works, Mr. Bradley?
Yes, sir.
And that's been talked between you and your attorney. Y'all have discussed that?
I don't think we discussed it, but
Okay,
would you
why
like
don't you
to
take a
discuss it
minute
more?
to do that?
All right.
All right, have you had sufficient time to speak with Ms. Safford about the way the notice of recidivism works?
Yes, sir.
Do you still reject the offer?
Yes, sir.
All right, the offer is rejected. All right. Thank you, Mr. Bradley.
Yes, I was desperately trying to hear her just see why 2 of her clients rejected these offers when they're facing such long, lengthy sentences. The first guy was just given parole. Now, I don't know about the possession of cocaine. So what the prosecutor said was it was going to be 15 years, do 5 on probation. But then he said, after that, he said possession of cocaine 3 years. But he didn't say on probation after that. He just said 3 years. So I don't know what that means. It didn't sound like he was going to jail at all. But instead, he's going to trial for trafficking. That's crazy to me. That's just crazy. Okay, let's go. This poor guy has issues. We're just going to go with some guy who has issues. So if you're thinking you have some problems in your life,
according to your what you told me on February 12th, Mr. Anderson, you had sent in a public defender's application.
Yes.
What, Ms. Yakir, do you see anything on Mr. Jared Anderson?
I do. It looks like Mr. Anderson is 1,558 over.
Okay, so you're over by $1,500, Mr. Anderson. So
But I'm not I don't understand because I only make like $2,000 a month. So I work at a grocery store. I only make like minimum wage. That's why I don't really like understand why they like didn't accept it.
Yeah, I don't know, sir. I don't make that decision. That's for the public defender's office to do. And I assume you took them proof of your income and they determined that you were more than a little over $1,500 over their guidelines. What is the current offer in this case, Mr. Smart?
A deferred sentence to a DWAI first.
Okay. Deferred deferred to a all right, deferred to a DWAI. What do you want to do, Mr. Anderson? Believe this is our second pretrial conference. Did you want to set it for trial?
So if you're brand new to court cases, deferred, it means that he's going to have to do some things that the prosecutor says for him to do. And if he does those things and completes it all, this case is going to be dismissed and it won't even be on his record.
Kyle, what did you want to do?
I'm honestly just trying to get this resolved. It's just been very stressful. I've had like some family issues and my legs are like really messed up. That's why I'm kind of confused because my job like lowered kind of put my hours down, and I'm honestly just trying to figure out how I can get through this and just resolve it, to be honest.
Well, I mean, do you want to accept a deferred sentence to DWAI? Mr. Smart can probably explain to you what that means.
Yeah, I'm honest. I'm not sure what that means, to be honest.
Okay.
That would mean that you would plead guilty to the charge of DWAI, which is an acronym for driving while ability impaired, but the conviction would be suspended upon successful completion of terms of probation. Those would be, you'd have to get an alcohol evaluation done, comply with the therapy and education as recommended by that evaluation. Supervision is determined by their recommendation, probation's recommendation. You would have to complete 48, or actually on a DWAI, you don't have to complete 24 hours of community service and then complete 2 hours of which have to be with a victim impact panel, usually through Mothers Against Drunk Driving, and then pay court costs and surcharges. If you complete all of those conditions and provide proof to the court within a year, then the conviction will be dismissed and sealed. If you fail to complete those conditions, then we will file a motion to revoke and attempt to enter the conviction against you with any further applicable penalties.
But the thing I understand is I have health issues. My immune system is damaged. I can't like even ingest alcohol. So would it, if I go to probate, I'll keep on kissing clean because I literally can't physically consume alcohol.
So an alcohol evaluation is, frankly, a little bit of an inaccurate way to phrase it. It's in reality a substance abuse evaluation. The officers noted that there were open containers of marijuana in the car. And so most of the education and the therapy would focus more on substances broadly, which in this case would be marijuana.
Oh,
okay.
Okay.
And you said it'd be like a year, it'd be like supervised probation or?
Supervision would be at the discretion of the court. It's normally imposed at the recommendation of probation after they complete their evaluation. And part of the agreement includes a stipulation not to disagree with probation's recommendation as far as supervision goes.
Oh, okay. And I have a question. If I were to go out of the country for 2 weeks, I had like wedding plans with my fiance, would that restrict it or?
That depends. If you have a bond, you would have to deal with getting consent of surety. As far as whether you are on probation, if this probation is unsupervised, normally that's not a problem. If it is supervised, then you'd have to talk to your probation officer about that. But normally I wouldn't have any objection. However, if you are on supervised probation, it's not a guarantee that you'll be able to head out of the country.
Oh, okay. Yeah, I guess I'll just plead guilty.
Well, you don't do that today. What we do is we set another court date for plea and sentencing, and then I order that you contact our probation department to set up an alcohol/substance abuse evaluation. So we can do that. I'll give you a court date. That would be April 25th at 1:30, 10:30.
Oh, okay.
April 25th at 10:30.
Oh, okay,
And then
10:30.
Yes, and I'll give you a telephone number that you need to call to talk with the probation department and set up your alcohol evaluation.
Oh, okay.
That date,
What's the
tell me when you're ready for me to do that.
Yeah, I'm ready, Your Honor.
Okay, it's area code 719
Uh-huh.
452
Uh-huh.
5901. And you
Oh, okay.
may have to be a little persistent because they're super busy. So just be persistent and call them, okay? And get that
Okay.
alcohol evaluation done. We'll have you back. I guess, Mr. Smart, do you want to email a proposed offer to him?
I'd be happy to. What's your email address, sir?
It's all lowercase. It's Jared, Jared. 701 @gmail.com.
Jared Anderson 0701 @gmail.com.
Oops, that was me.
All right. All right, so Mr. Smart will probably email you that proposed offer. It may go into your junk. I think it comes from something called Sign Now. So it might go into your junk email from what I understand. So just keep an eye out for it, okay?
Oh, okay. And then how would probation work? Because I don't live in. So the reason why I left Colorado, I was trying to live there, and I was there for like a couple months. The place I was living at, they locked me out of the trailer, and I was like in the cold, and I wasn't really trying to sleep. Like if I'd stayed there, the reason I came back here because I would have to live in my car. Like so, I
Sure.
have like.
I gotcha. I don't,
Yeah.
that is going to be something, it doesn't look like you are currently on bond, Mr. Anderson. So, your question about going out of the country for a wedding, it doesn't look like there's any restriction on that. But, I'll certainly consider whatever you want to tell me, as well as what the probation department recommends concerning supervised or unsupervised. But they do have cooperative arrangements, I guess, with other state probation departments. So, Colorado you could be supervised in Maryland out of, the Maryland probation department if that was the ultimate order.
Oh, okay.
So you wouldn't have to come back here.
Oh, okay.
Okay?
All right. Thank you.
All right. Thank you, Mr. Anderson. You stay safe and healthy.
Oh, you too.
Thank you. Bye-bye.
Bye.
James, you're right. I think I would rather just do straight jail and no probation attached, even if it meant that I had more jail time to do, because probation just sounds terrible. I'm sort of on probation now because I don't break the law normally. I live like my life that I don't break the law. If I was on probation right now, I'd be perfectly fine. But it still sounds terrible. Okay, I think I'm gonna try to turn the volume down, but I think just to be safe, maybe you should turn your volumes down a little bit when I play the last of this, because I think it's really loud. I edited it, put the volume down. I don't know why, it just seems super super loud in California, and we're gonna spend the rest of the time we have together tonight in California, because it was just in California. All right, here we go. I hope your volume's down. Hold on, keep it down. There.
Yes, please. You have three cases, case 23 FE 015240 on for return on a bench warrant at settlement conference. Case 23 MI 019987. Offense date September 21st, 2023, count 1, possession of narcotics in violation of Safety Code 11377. Case 24 MI 003831. Offense date December 5th, 2023, count 1, trespassing on lands without their own permission in violation of Penal Code 602K. Count 3, possession on private property in violation of Sacramento City Ordinance 9.80.010B. As to all three cases, the public defender is appointed.
There's exactly appointed and we as well as cases over to
I know you got a jail, man. Please click the
okay. Can we have March 18th, 8:30, 61?
Can I be March 18th, 61? Ms. Leonard, I'm not going to release you in light of the fact that you missed court. I didn't know. And you have a bench warrant for a settlement conference. Please, I've made my ruling. That'll be the order. Please, you understand how sick I am. I need to get out of jail. I've made my ruling. I'm out. I'll bet if you're going to please let me out. Please let me out, ma'am. Hold on. I'm 52 years old. I've never been in trouble before in my life. Miss Leonard, I've made my ruling. I'm not changing my mind. Please let me out. Please let me out. I can't eat in here. Please. Call me in here. Please.
She left the bench. She said, I'm out of here. I don't know if I got it, but she's looking for her. She's like, where'd she go? All right. We're staying in California, so don't turn your volume back up yet.
Gerard Calhoun, Kenneth, why do I keep doing that? Every person who's named Kenneth, I keep doing the wrong thing. Kenneth Gerard Calhoun, is that your true and correct name?
Yes.
You have 4 cases, sir. 18 MI 005003. Case 22 MI 013013. Case 23 MI 000807. All 3 of those are on for return on a bench warrant for further proceedings. Then you have case 24 MI 004153. Offense date March 10th, 2024, count 1. Willfully and knowingly violating the court order in violation of Code 373.6. Public defender.
Judge, she hasn't.
Well, I'm still going to say it. How can you give her a court order to have a restraining order when my sister lives out of state? That doesn't make any sense, man.
Mr. Calhoun's matters. The request at this time is to enter not guilty pleas on all counts.
I want to know, how do you give me a restraining order when my sister lives out of state? Mr. Calhoun, I either need you to stop or I'm just going to know you not answer me. Because, Mr. Calhoun, I'm only here to tell you what the charges are. I have no details behind the charges in front of me. Now, 2 things that are not going to be acceptable in this courtroom is you yelling at me. Are you telling the truth? I am only here to tell you what your charges are, sir. I have no information about the details of the facts of the case. You'll need to talk to your attorney about it. Now, if you interrupt the court one more time, I'll have you removed. Go ahead, Mr. Clemmer.
Thank you. As to all those cases, I was asking that they be set. With date and time, my first day is 30th day is April 11th. That's correct. And I'd ask for a jury.
That is correct.
Jury trial April 8th. 8:45 will be assigned to Department 9. Readiness conference, Department 25th, 8:30, Department 61.
Who's the not guilty? 8:30 or 1:35?
I'm sorry.
Who's the not guilty will be entered as to all 4 cases. For the record, the 30th day is April 11th. The trial readiness conference will be set on March 25th, 1:35, Department 61. And the jury trial will be scheduled for April 8th, 8:45, Department 9. That'll be the order.
Sorry, it's clear. That's considered something.
I'll tell you what, Mr. Dixon, I normally wouldn't do this. I'm feeling a little bit more generous at this moment in time, so you're gonna get the benefit of that. Please don't let me down. I promise you I won't.
She's never generous.
What I will tell you is that your public defenders, we have a pre-court meeting. During that pre-court meeting, we discussed your case. And I reviewed your pretrial packet. I reviewed the number of times that you failed to appear within the last 2 years by themselves, not even considering any failures to appear, just in the last 2-year period. You failed to appear 9 times. I am not confident that you will return to court. I know you'll tell me that you will. I am telling you that I am refusing to release you. But I have never had anything in my life, and I promise you, on everything, I just got out of the hospital, and I understand, sir. I made my decision. I'm homeless. I'm on the streets. If you put my on them, I promise you, I will do everything in my power, man. Unfortunately, sir, 9 FTAs in 2 years is just too many. For me, it's just too many for me, sir. That guy didn't have 9 FTAs in 2 years. I promise you, ma'am.
Okay, we're going to do a little bit more in California, and nothing really happens to the first guy. He just demands attention. So I gave him attention. He's only on for a few seconds. Oh, and about the cage, they're only in there for a short amount of time. They bring in small batches. They go through them pretty quick, and then they're out again. There's a door right at the back of the cage into the next room or the jail or whatever. So it's not like they're there for 8 hours standing all together huddled in a cage. They're only in there for a few minutes.
Page 21. Hello? Kyle
Patello, is that your true correct name?
Oh. Okay. Is there a Patello here? No. 134 and 135, Mario Smith. Yeah.
Mario Bernard Smith, is that your true correct name? Yes, it is, ma'am. You have 2 cases in front of me. Case 22 MI 017218. On for return on the bench warrant from further proceedings. Case 23 MI 020144. Offense date September 19th, 2023. Count 1. Possession of narcotic paraphernalia in violation of Health and Safety Code 11364. Count 2, destroying evidence in violation of Penal Code 135. Public defender is appointed.
Thank you, Your Honor. Now, such policy for the public defenders. We request that you come back on March 19th at 8:30 and 62. We order a JPS visit.
March 19th, 8:30 and 62. JPS visit will be ordered.
Now we have a name issue next.
Kyle Ray Patello, is that your true and correct name? I need you to say so verbally for the record, sir. Is that your true and correct name?
Yes.
This is case 24 MI 004198. Offense date March 8th, 2024. Count 1, religious threatening with a weapon in violation of Penal Code 417A, paren 1. Public CCD is appointed.
Thank you, Your Honor. Go home with accepting appointment, wait formal arraignment and advisement. Right, acknowledge a copy of the complaint and discovered. May I have a moment?
Yes.
Sorry, the name issue is in a couple minutes. I got it wrong.
Pass
this matter. Willie Lamar McDaniel, is that your true and correct name?
Damari McDaniel Lamar Wiley. Wait, Damari McDaniel Lamar McDaniel Wiley. Yeah.
So it's Damari Lamar McDaniel Wiley. All right, thank you for the clarification, sir.
His name.
This is case 23 FE 016812.
Recall 21 Patello.
Returning to Patello, what's the request?
At this time, Your Honor, Mr. Patello does not have another place to stay. So the court wants to continue this to May 18th at 8:30 in the department.
Do you want to continue it to May 18th? I can't let him out if he doesn't have another place to stay.
Can I speak, Your Honor?
I will speak for your attorney, sir. It's in your best interest not to say something that you think might be helpful, but ends up hurting you. So I would talk to your attorney and have her convey it to me.
And I do. I have a receipt.
Okay. At this time, Your Honor, we are requesting that Mr. Vitello be released on his own recognizance with the stay away order and continue this to April 24th at 8:30 in Department 3, please.
So you understand you have to have a new place to stay. You cannot go there even if that person says it's okay.
Can you say that? There are positions that I need to be the sheriff.
Your Honor, he is just saying some of his possessions are still there, but
You have to do that through the sheriff's, through the sheriff's.
Can I ask, can the judge ask the sheriff to take me there?
No, I can't ask the sheriffs to do anything. You have to contact the sheriffs. I'm gonna need that name again, this opinion. I whited it out when I was told that we weren't really named her, so.
okay. The victim name, the first name is Kaimana, and the last name is Kaili. And just for the record, the people are objecting to release in this case based on the fact that the defendant entered the room with a knife. He was the roommate of the victim, and he said, "I'm going to kill you," while brandishing the knife. And the victim was in fear for his life. The victim also did contact acquaintance at the public defender's office and told him that he's very fearful if the defendant were released. And I believe that's the reason for the conflict in the case, but that public defender relayed the information to me as well. Additionally, the defendant refused to listen to officers' commands for 15 minutes and was ultimately detained, and the knife was located. In light of his conduct, the weapon, and the threat, and the victim's fear, the people are opposed to his release.
So I want to make something clear to you, sir. I will release you, but my condition is that you stay away from the victim in this case, that you cannot go within 100 yards without, when you go to your stop, that's a different, you still stand by for the sheriffs. But that's the only way. Even if they say it's okay, it's not. I want you to listen all the way through. It's not okay because it is a court order. And until that order is lifted, you are not to go anywhere near the residence, the work of that individual or that individual being. I don't know how to pronounce it. It's Kaimana, Kaimana.
Or is it there?
Kaili. You understand and agree to my conditions, sir?
Just too hard of me. Because I can close my door and I can go out the garage.
I think at this point in time, based on some of the confusion and some of the questions that are have, I think at this point, we're not going to allow the defendant. At this point, I will let the defendant work out whatever he needs to work out, and you can ask that question to the next judge.
If I have my materials, I can go. I just need to help.
Again, I will give you the directions as to how to do that. If you don't want to comply with that,
Never mind, I apologize. They can't.
then I'm going to make it.
Your Honor, I understand.
Well, I want to make it clear, sir, because if you don't obey this,
I understand.
Then you're back in here and you're stuck in here, and it's not going to be, we're going to put it over for you to figure it out.
Right.
So I want to make clear to you, if right now you don't have a solution for this, we can put over your pretrial hearing to the next date, and we can try and deal with it then. But if you're found in violation of what we've asked you to do, you cannot come back and say, okay, now I'm going to do it. So I want to make sure that you really understand what it is that I'm telling you, okay? Because it's very important. And so if you don't understand or you cannot do it at this time, that doesn't mean no permanently. It just means right now is not a good time to release you.
I think now, sorry.
Go ahead. Go ahead, sir.
Now is a good time to release me. I know where I need to go. And I can take care of the rest from there. I will do this.
You cannot go there and pick up any of the stuff. You cannot call that person. directly or indirectly. You can't message them. You can't do anything. There's no contact. I'm concerned about that myself, but I can handle that through. Again, what I want to make so that you understand, the order's a one-way street, unfortunately. Now you can pursue it through other means if you need to have some sort of stay away. But right now, the only person who is ordered to stay away is you. There is no order placed on the other individual. It is only on you. So all the obligation in this circumstance is on you. So if that person comes near you, you need to walk away. You understand. Now, there are other means that you can have stayaways. You can go seek a restraining order on your own if that's what you want to do. But I cannot place one on that person at this time. All right. So, Ms. Mukhtar, if you want just a second, just to verify that we're ready to go. My concerns, I don't know what's up to the list. Make the decision. We'll pass this matter for a moment. Do you want to call one of the other? 110 Timothy Pasalis at 77. Timothy Pasalis.
At this time, he would like to get released on his own recognizance with the stay away order. And continue this case to April 24th at 8:30 in Department 3, please.
I will order that you be released on your recognizances with the stay away from the individual I had previously mentioned on the record. April 24th, 8:30, Department 3 is your next court date. Do you understand and agree to the conditions of release, sir? As far as I know, as long as I can get what I need tomorrow, I'll be fine. So again, there is no condition as long as you get what you need. My only condition is that you stay away. There is no but that follows it. Do you understand? That's fine, as long as at some point I can get a hug from him at some point as my friend and my confidant. So that's the only thing, that's the condition. I'm gonna at this time, I'm going to not release you because I keep hearing I will accept. And I can't I've repeatedly tried to tell you that you cannot say the words under this condition. There is no conditions you can add to my condition. I've tried to explain it to you. You keep trying to add them. I do not at this point feel comfortable that you're going to comply with my orders. So at this time, I'm not going to release the defendant.
In that case, maybe come back March 18th at 8:30 in Department 63, please.
March 18th, 8:30, 63. That's fine.
And Your Honor, will the stay away please stay in effect? Just
the stay away, if he were to be released, if the defendant is released, he is ordered to stay away from the individual mentioned previously, Mr. or Ms. Killai.
And if he's in custody, he may not call the defendant, call the victim either.
Either. I wouldn't call the complaining witness at all. That'll be the order.
Case 62, Goldstein.
Poor Jesco. Jesco, it's over. I'm so sorry. That's how late you are. Oh, but you can rewind it. It's all good. It's okay. Yep, she kept him in custody. She was like, no, I'm not releasing you. You won't listen to me. I'm not releasing you. And all he had to do was say he was going to listen to her. It's all he had to do. Oh, man. I don't know, Debbie. I don't know if he didn't understand, but I just think people are so used to getting their own way that they expect to always get their own way in every circumstance. And they don't know how to act when they're in a circumstance where they don't get their own way. Like they feel they're always going to have to be in control of themselves. And that's just not life. It's just not. So tomorrow night or morning or tomorrow or later today, I don't know. It's going to be a bunch of habeas cases in a row. Maybe I don't know how many there are. Not a lot, but that's what we're going to do tomorrow. So these people have entered pleas and are in jail, and then they're like, "Hey, wait, my lawyer didn't work hard enough for me, or I didn't know that this guilty plea was going to make this happen, or blah blah blah." So they're going back to court to say, this ain't right. I shouldn't be here. So that's what we're going to do tomorrow. I think it's in Georgia. So it'll be fun. I think they have the real thick accents, so that makes it just so much better for me. I don't know why, but that's what we're gonna do tomorrow, today, later, who knows. But whoever came out today to see the Sov Cit, I'm glad you did. Thank you so much, especially you, Debbie, who had other options and said heck no. And was it Jane? Were you the one that couldn't sleep? Yep. I hope you can get to sleep. I'm literally putting a video together of this judge from Colorado. Her voice is so soft, and she puts you right to sleep. And I'm going to call it sleepy time. So that way, if you want to watch court cases but you need to go to sleep, you can compromise. You can pop this one on, and she'll put you right to sleep. She really did. I did, Kelly. I did, about the attacker. Yes. Snooze judge. Yeah. I can't imagine anybody will watch it. It's really boring. But I'm just gonna upload it as a video, not a live stream, because then I'll fall asleep. And that's what I'll call it, sleepy judge or snooze judge or sleepy time or something like that. Because videos that put you to sleep, I use them. I watch videos to go to sleep. All right, guys, thank you so much for coming out tonight, this morning, or whatever it is, wherever you are. No, she's not. She's a brunette. Let me see. Hold on. Maybe I have a little piece of her that I can pull up real quick. Hold on. When I say real quick, it's probably not real quick. I thought I did. It's probably on my other computer. It is. It's upstairs. She doesn't drone on. Her voice is just so soft. Oh, the redhead. The redhead drones on. I got it. Sort of like I'm doing now. Chat was fun again tonight, guys. Thank you so much. I will see you next time. Have a great day. Bye.